Hello everyone, welcome back to my channel Beyond the Briefcase. I hope you all are doing well. So I welcome you all to the legal segment where I discuss important landmark judgments given by the Supreme Court on any specific topic or with regard to any particular provision or section. So recently, Supreme Court they commented on Section 47 CPC that applications raising property rights after passing of decree to be treated as application under Order 21 Rule 97. So let's jump into it. What exactly Supreme Court held in this particular case? So, the Honorable Supreme Court observed that an application filed under Section 47 of CPC relating to the determination of questions with regards to execution of the decree, and as you know, the decree execution of decree does fall under the ambit of orders and rules of CPC, and so this particular application filed under Order 21 Rule 97 if it raises questions of right, title, or interest in the property. So basically, three things which is very important as per this particular paragraph, which is right, title, and interest in the property. The court further clarified that applications which filed under Section 47 of CPC and also under Order 21 Rule 97 addresses distinct proceedings. Also, with regards to concerning execution, discharge, or satisfaction of a decree, and the resistance and obstruction to the possession, by the third parties, obviously. So, also the judgment data or the aggrieved third party will be treated as one under Order 21 and Order 97. So that's the clarity which Honorable Supreme Court gave. Also, in such cases, the executing court must, adjudicate these questions under Order 21 and Rule 101. So the Honorable Bench, Justice G.B. Pardiwala and Justice Pankaj Mittal, they heard the case and in which the respondents filed an application under Section 47 of CPC after a decree was passed in the appellant's favor and asserting the status as bona fide, cultivating tenants to prevent their disposition from the property. So initially, that's why I mentioned judgment data. Why it's a very important term, in such cases, because initially the respondents, the degree was passed in the favor of appellants' favor, and then the party they appealed in the Honorable Supreme Court. So this particular case, the name of the case, I'll show you the judgment of this particular case. So this is the judgment Perimal legal representative and others versus V Rajamani and others. This judgment was pronounced on 6th of March. Citation you can see 2025 Live Law SC 293. Uh, so for this particular, this from the perspective of this particular judgment, Section 47 of CPC, also the role of Order 21 and Rule 97 and Rule 101 of CPC. Those things are very important because specifically when we talk about execution of decree, discharge, also the role of third parties in such cases, the distinct proceedings. So this particular section and orders and rules, they give us so much of clarity with regards to those terminologies. So do remember this particular case. If you're preparing for any competitive examination or even if you are in, graduation. So this is very important because see, CPC is a very, according to me, CPC is a very important subject. Whether you are pursuing judiciary, whether you're pursuing litigation or you're in corporate, but you should know CPC very well because without CPC, you cannot do anything. So it's a backbone of the law, according to me. So this was the case. Moving ahead to the next case law. So Delhi High Court they ordered to take down the content which was published by the YouTuber Sham Meera Singh, and he so basically this person he created various videos on Isha Foundation that so basically Isha Foundation they filed a complaint that those videos are very defamatory in nature, and that's why the Honorable High Court, Delhi High Court, they ordered to take down those content from the YouTube. So let's see what are the small. Let's see the what exactly the epitome of the whole case is. So the video title Sadhguru exposed what's happening in Jaggi Vasudev's ashram was uploaded by Singh on his YouTube channel on 24th February, and he shared it on his X page with allegations suggesting it that minors were being exploited in the ashram. Do let me know in the comment section what do you think about this particular thing which Singh published. Do you agree with him? Do you not agree with him? Also, at present, the video has 937K views and 65K likes, 13K comments. Justice Subramaniam Prasad directed defendants Google LLC, X Corporation, Meta Platforms to take down the video in question. The bench also restrained Singh from publishing, sharing the video in the question in the interim. So that's what the honorable court said, and they stopped the particular person to publish further publishing those contents. Also, in its order, the court said that Shyam Mira Singh made the YouTube video based on unverified material and that the title of the video is clickbait to attract public attention. So nowadays, as you can see, that even in people, they are making so many videos, just and also they are making fake thumbnail just to get your views. You must be knowing there are so many YouTube channels, even talking from the law perspective, they do give unverified information. Like recently I was watching somewhere that people they are telling that 176 vacancies is coming in the Bihar judiciary. Now, as of now, we don't have any official confirmation, official notification. Still people, there are so many prominent law channels, even those people they are making such videos. So it's a shame, I would say, that you don't have concrete information, you don't have any government authorized information, yet just to get the views you're making such videos. So it's their thing, it's how they go about it. So this is a particular thing happened in this particular case. So also talking about this particular case, the parties they said that it is well settled that reputation is an integral part of the dignity of each individual, and there is a need to balance between freedom of speech, freedom of expression. A right to reputation has been considered as a part of right to life under Article 21 of Constitution. So this particular honorable court said this particular thing while citing the order, and this is the order which was given by the honorable judge. You can see all the lawyers who appeared on the behalf of parties, advocates, and this is the order which honorable court gave. It's a big order, 10-page order, and they have also mentioned the links of the YouTube channel where he published those materials on Sadhguru, and they have given citation of Morgan Stanley Mutual Fund versus Karthik Das, 1994, and citation other cases as well. You can see for your knowledge and compliance of order uh, 39 rule 3. So you must be knowing that order 39 of CPC talks about temporary injunction. So this was the full order. So the case name Isha Foundation versus Google LLC and others. So moving ahead to the next case. So Honorable High Court, they were very clear with regard to this particular case that Negotiable Instrument Act allows filing of check dishonor complaint at place of pay bank. Accused can't seek transfer citing inconvenience. So if you are facing the same issue and if you are an accused, then it's a very bad judgment in your favor, obviously, because you cannot cite, you cannot give a reason that it becomes very inconvenient for me to travel just for the case proceeding. So the Honorable Supreme Court, 6th March, they ruled that a check dishonor complaint under Section 138 of NI Act. You must be knowing that 138 is a very famous section of NI Act. So many lakhs of cases, it comes every day just on this particular section. Should be filed in the court having jurisdiction over the branch of the bank where the payee maintains an account, where the check is presented for collection. Taking reference of Section 142 Clause to introduce via 2015 amendment to the NI Act, the court clarified that the jurisdiction to adjudicate upon the check dishonor complaint lies with the court where the branch of the bank is located. So that's very important with regard to jurisdiction. So I would say that this particular judgment is related to Article Section 138 of NI Act, and the Main thing is jurisdiction, what the court has clarified in this particular section, along with section 142 clause 2 of NI Act. So, Honorable Bench of Justice G.V. Pardiwala and Justice R. Mahadevan, they decided a transfer petition where the appellant sought a transfer of check dishonor case from Chandigarh to Coimbatore, contending that the entire transaction occurred in Coimbatore and thus the Chandigarh court lacked jurisdiction. Rejecting the petitioner's argument that the entire transaction occurred in Coimbatore, the court stated that the law allows the complaint to file the complaint at the place where the check is presented for collection. So that's the clarity which Honorable Apex Court they have given. And let's see the judgment name. So this is a citation 2025 Live Law SC 292, and this is a judgment's copy. Apologies for my slow internet. Sometimes it doesn't work. I think it's not. Yeah, it worked. Yeah. So this is a case name Shri Sindoor Agro and Oil Industries versus Kotak Mahindra Limited. So, and the citation, as you can see, honorable, it was a two bench. Also, you can see the it was a dual bench judgment, and the sections which they have mentioned in the judgment. So they have mentioned various sections, but the whole thing was about section 138 of NI Act and section 142 clause 2 of NI Act, and even they have mentioned CRPC section 1406, Surface Act also. And this is a whole judgment you can see, and you can read all the important precedents, important terminologies which they have used in this particular case law. So if you need the copy of this particular judgment, you can ping me in Instagram or Telegram. I'll send you the copy of this particular judgment. So moving ahead to the our last judgment, no civil judges appointed. Apologies again for the error. Yeah. So no civil judges appointed in Bengal since 2021 batch. Qualified candidates left in endless limbo over non-appointment. So yeah, I being myself as a judiciary aspirant, I know how much it hurts. Even if you have qualified the examination and you're not getting the offer letter, you're not getting the adequate training, it hurts. And clearly it shows the inefficiency of the state government and how they are functioning. It's been 4 years, and these people, the state government, they have enough money, to give on various type of schemes just to show their weightage, just to show their coverage in the whole state, and just to show off, basically, I would say. But they don't have money for the public welfare. I think recently I was reading somewhere there that for 30 lakh people, there is only one High Court judges who is dealing with the cases. So that's the capacity of High Court judges we have right now. We do have sanction strength. We do have it's too much higher, but we have very limited judges because again the central government, the state government, they say that they don't have adequate budget for recruiting judges, and I don't think so that they are right because they do have enough money, but they just don't want to spend on judiciary. That's my opinion. Because if you see the data, it clearly shows that they do have enough money, but they're not spending on judiciary, and that's how public they suffer. The public in large, they suffer a lot. And this is a classic example which I was talking about. Qualified candidates of West Bengal Judicial Services Examination 2022 have been left in endless limbo over non-appointment to civil judge junior division post since exams were conducted in 2023. It's been almost 2.5 years now. And people who gave the preliminary examination 2022 batch was held in March 2023. So yeah, it's been 4 years. The people who have cleared the examination, they haven't got their appointment letter. And this move is a clear violation of Supreme Court judgment Malik Mazhar Sultan versus UP Public Service Commission 2008, where it was held by the apex court that the entire procedure for judicial service examination shall be completed within the time span of 1 year. So this is a permanent, perfect, I would say uh, precedent given by the Honorable Supreme Court, which even the state government is not following. So yeah, it's a clear violation. This clearly shows that the state government, they are not respecting the Supreme Court. They are not respecting the judgment of Honorable Supreme Court. So, according to Law Ministry's data tabled at the Parliament in 2023, just now I spoke about this particular thing that, as per the data published by the Law Ministries, West Bengal had 6,22,950 pending civil cases, while it had 2,20,000. I'm not good with numbers, but you can see the digits. Yeah, sorry, 2 crore 28 lakh 5,565 pending criminal cases before the various trial courts across the state. So if you are not recruiting the judges, then how do you expect from the existing judges to complete so many cases? Because as you all know that it takes a lot of time for even for the judges. They'll give you 5 to 10 minutes to brief you on the case. Then they'll have to check the relevant provision section and all those things, precedents, judgments. Then only they'll be able to give you the judgment. It's not a it's a very complicated job to do. You do need manpower a lot in form of civil judges, and you're not recruiting. I think it's onus of public to ask this question from their honorable CM, that why she is not recruiting judges in her state. I guess she doesn't want cases to get moved quickly. So yeah, that was it from my side. Do comment if you need any clarification, if you need any help, and what's your opinion on all these issues. And you can reach out to me through my Instagram handle, Telegram handle. Do join my group. I keep sharing various vacancies in my Telegram handle. And stay tuned for more videos. Share with your friends, like it, subscribe, and thank you so much, people. Thank you so much.